First of all, on behalf of IBJ India, Criminal Justice Group of Delhi High Court and Bar Council of Delhi, I always welcome everyone here. And all the honorable distinguished speakers have joined the session. And as this is a very historical session today, we have on the evaluation of Juvenile Justice Committee by Honorable Justice Rajiv Shakdar, Judge Delhi High Court, and the Chairman of Juvenile Justice Committee of Delhi High Court, and Professor Ved Kumari. And this is for the first time in the history we are having this discussion over the public forum, and all of us are very much familiar about the Juvenile Justice Act. But if you read the JJ Act and rules, there will not be any mention about the Juvenile Justice Committee in the laws. We know the Juvenile Justice Board, Child Welfare Committee, Children's Courts, and might confuse JJC with something like JJB and CWC, but this is not the case at all. JJC is a Supreme Court and the High Court level institution set up on the administrative side and situated with the Supreme Court and the High Court, comprising of and headed by the sitting judge of the Supreme Court and the High Court. So far as nothing is available in public domain on Juvenile Justice Committee, and neither is there any public or academic documentation available on this institution. Our speakers will educate us today on this, and that is why the lecture assumes a historic significance. Let me inform you that the Juvenile Justice Committee was set up in the Delhi High Court in 2006, and of 2020, each High Court of the country has Juvenile Justice Committee. In the Supreme Court, presently the committee is chaired by Honorable Mr. Justice Ravindra Bhatt sir, and in the High Court it is headed by Honorable Justice Rajiv Shakdar sir, who is also today is one of the speakers and will be enlightening us on this subject. The JJC is the only institution of its kind in the entire world, I can say, and can definitely, in my view, be seen as a unique contribution which Indian judiciary has made to the development of judicial review. It has given birth to a new concept and a non-adversarial, non-judging practice of judicial monitoring in the form of JJC, if I may say so. While today we will hear about this institution from two esteemed speakers, I want to urge everyone not to confuse this event with the usual lecture on Juvenile Justice Act and confine your comment inquiries exclusively on Juvenile Justice Committees. And I must inform you today that on the initiative of Directorate of Child Rights, Government of Rajasthan, many stakeholders from Rajasthan are attending today's event. Similarly, on the initiative of Delhi Judicial Academy, many probationary judicial officers are also attending today's event. And I'm also hereby welcome many of the people, lawyers from Myanmar, IBJ Myanmar, and from Rwanda joining in the session today. And here, before we start, I would like to request Mr. Ajendra Sangwan of Member Bar Council Delhi to give a welcome comment on this session.
Officers from across India, Jatan Singh Ji, Vice President Delhi High Court, Ajay Verma, co-founder of Criminal Justice System, and other esteemed viewers, I welcome you all. Section 6E of Advocates Act cast upon duty of Bar Council to conduct seminars and organize talk of topics by eminent jurists. To perform a duty, Bar Council of Delhi, in collaboration with Criminal Justice Group and IBJ India, has organized series of lectures on various topics. Today, the topic is Historic Evolution of Juvenile Justice Committee in India. To enlighten us on the topic, we have two speakers, Justice Rajiv Shakdar and Professor Ved Kumari. Justice Rajiv Shakdar needs no introduction, most humble, soft-spoken and bold judge we have in Delhi High Court. Justice Shakdar is the chairman of JJC Committee of Delhi High Court. Justice Shakdar did his law from Delhi University in 1987 and also chartered accountancy. Justice Shakdar practiced in Supreme Court of India and other courts and have vast experience of constitutional law, civil law, commercial law, and taxation law. Justice Shakdar was designated senior in December 2005. Justice Shakdar was appointed in High Court as judge on 11th of April 2008 and has passed landmark judgments in all fields of law. Sir, I welcome you all once again. The other eminent speaker we have is Professor Ved Kumari. She has been my teacher also. She's been teaching since 1983 She has been lecturer, reader, professor, dean, and head of the faculty. She has written books on juvenile justice system in India and is authority in herself on the subject. I welcome you, ma'am, once again. Thank you. Over to Ajay.
Thank you. Without any delay, I request Honorable Justice Rajiv Shakdar sir to comment on the today's subject.
Let me wish you all a very good afternoon and thank the organizers for inviting me on this webinar. The organizers of this webinar are International Bridges to Justice. This organization is partnered, I'm told, by a group which goes by the name Criminal Justice Group. Handholding has been done by the Bar Council of Delhi. So thank you, Mr. Ajay Verma, Mr. Ajendra Sangwan, and our very own Vice President of Delhi High Court Bar Association, Mr. Jatan Singh. The importance of this webinar, according to me, is in the fact that we are today in very trying circumstances. Therefore, for people like you who are, as I would call them, the leaders of the bar, to think about children and have this webinar organized is in itself a very important facet. The story of children who are abandoned, orphaned, mauled and abused needs to be told. And to my mind, there is no better way of doing that but by getting together and discussing what is this juvenile, as I call it, the administrative mechanism all about. So therefore, the topic that one has to address, which is historical evolution of JJC, is really a story of the children of this country and how the courts got into what was earlier within the exclusive domain of the dispensation of the day. The story of evolution actually, to my mind, and that's how I look at it, is also a story of realization. Realization that the manner in which the act was being administered, because we've had JJ Act now for a very long time, much before the constitution of the Juvenile Justice Committees. It was really, therefore, realization of the fact that the act was not being administered in the manner in which it had to be administered. It is, to my mind, also a story of learning, because when you are administering an act, there are various outcomes. You learn, you fall, you get up, you learn, and then you make course correction. So therefore, it is also a story of course correction, which is continuous. If someone were to say that I have got the system right completely, he would be making a huge mistake. So when did the story start? After the 1986 Act, we had the 2000 Act of JJ. And it was brought to the notice of the courts that there is a huge gap between what the Act mandates and what is actually happening on grounds, i.e., there are not enough juvenile justice boards in various states, and therefore there is no oversight as to how the interests of children are taken care of. The interests of children, as we all know who are familiar with the Juvenile Justice Act, are taken care of at various levels by various bodies. You have the child welfare committees, you have the juvenile justice boards, then you have in most states exclusive department for women and child. But there was no intercession by the court at this juncture when this story really evolved. And in 2006, the exact date is 9th and 10th March 2006, at a Chief Justice's conference, which was convened by the then Chief Justice of India, a resolution was passed that the High Courts must impress upon various state governments and union territories that there should be a juvenile justice board in each district of their jurisdiction. And a further mandate was given that a sitting High Court judge should oversee as to what the JJBs are doing. It is this resolution passed at the Chief Justice's conference which led to the birth of the Juvenile Justice Committees. Delhi High Court, I think, was one of the High Courts which was fastest to react to this resolution, and on 25th April 2006 we had the first JJC constituted insofar as the Delhi High Court is concerned. And happily, the chairperson of the Delhi High Court Juvenile Justice Committee, the first chairperson was Justice Madan Lokur, who, as all of you have read and would have heard him at various forums, after he reached the Supreme Court, he carried that work further because he was given the responsibility of running the JJC at an all India level. And therefore he could, push certain ideas and agendas which benefited the children. But if you look closely at what happened after the constitution and thereafter, you would find that the movement was slow because the state was getting, used to the idea, and very slowly, that the courts were now getting into administration. Ordinarily, the courts sit on the judicial side in benches of 1s and 2s or more. They have a case coming before them, either someone would move a petition in his personal right, or there will be a PIL and a slew of directions will be issued. But here was a mechanism where the court and its sitting judges were on the administrative side, getting into areas which were till then within the exclusive domain of the state. So therefore this adjustment had to take place. And you would find, if you look closely, and these are things for the academics, that the movement was slow and it was almost glacial. We had a situation where there were not enough JJBs in the High Court, in the country. The reasons for them were many, but broadly, you had to find the right kind of officers. You had to divert the officers from judicial work to juvenile justice boards because you needed a principal magistrate along with two people who were from the civil society. So the process of selection, the process of providing for infrastructure, then each JJB had to have other officials attached to them, and the various legal services authorities had also to provide the necessary support by having their lawyers appear before the JJBs also. But what has happened in Delhi is this, that because of the support given by the court on the judicial side, and I must say that the Delhi High Court on the judicial side has done wonderfully well, in the sense that they've always gone out on a leg to pass directions which ultimately inure to the benefit of the children. And of course, the Supreme Court, when it passed directions on an all India level. So today we have in Delhi 6 juvenile justice boards. We are pushing for more because we are looking at a goal where we have a juvenile justice board in every district. The handicap is, of course, that The state government doesn't have enough wherewithal, or at least that's what we are told. We have 10 CWCs, which is child welfare committees. And for those of you who are not familiar with the Act, the JJBs deal with children who are in conflict with law, whereas the child welfare committees, i.e. the CWCs, deal with children who are in need of care and protection. Apart from that, so therefore, these are the two bodies mainly who, under the Act, look after the welfare of children who are institutionalized. Institutionalized both in government homes and non-government homes. The government homes in Delhi are about 16. There are about 57 homes run by non-governmental organizations. There are places of safety, observation homes, 3 observation home places of safety. So as far as Delhi is concerned, we are, as I would say, if I were to analyze where we are, we have enough mechanism in place, but we need more, because ideally all these bodies, which is essentially the JJBs and the CWCs, should have an optimum number of cases before them, so that they are able to spend more time with the children who are brought before them. It is only when they interact with them are they able to help them better and able to assess what exactly has gone wrong. Because, long ago I was told by someone, all of us got initiated into this area of law. As lawyers, perhaps we were not exposed to doing other jurisdictions. But as a judge, I got exposed to it, and I asked in my initial years when I got introduced to the JJCs, because earlier I was a member of the JJC. In fact, Justice Bhatt at one time headed the JJC after some interval, because as I told you, Justice Madan Nukur was there earlier. And I asked a person who had worked in this field for a very, very long time as to, how do you deal with children in a passionate manner as that person used to deal with. And her answer was very simple, and this is something that I want people who are dealing with children to carry home. Her answer was, and she turned around and said, Justice Shraddha, all of us went through childhood, but there was a generation where when a child had to be told that something he or she did was not right, the parent would always invoke some form of threat of punishment. I mean, there were very few who raised the cane, but they would always say that if you do not do this, or if you do this, I would either slap you or lock you up, or those kinds of threats. So she said, the trouble is that most of us don't think children are intelligent enough. There is an age when they are intelligent, or they understand what you are saying. We don't talk to our children enough. We talk to people of our age or older than us. We don't threaten them with, some kind of punishment that if you don't agree with me, I'll slap you. But with children, it comes easily. So the approach is to dominate. And that is where sometimes children go wrong. I mean, some of us belong to an earlier, and I include myself to an earlier generation. Nothing wrong happened to us. Our parents perhaps, said these kind of things, and some of us perhaps even in school, or by our parents once in a while, did face their wrath. But the message went through that you need to engage with your children. The second thing that I was told was that when you deal with children who are not your own, you don't look at their interest as you would perhaps for her own child. So the example that she gave me was that when you're looking at children, and unfortunately because of funds we can't do much, or children who are orphaned, abandoned, who are in homes, we are always looking for low-level rehabilitation, routes, i.e., give the child a course in tailoring, give a child a course in mobile repairing, give a child in a course in hairdressing. So the message that she gave me or tried to impress me with was, we are not looking at these children to be achievers in other areas as we would look for our children. Not that there is anything wrong. There is dignity of labor and everything. Whether you're a tailor, you're a mobile person who repairs mobiles, or does some hairdressing job. There's nothing wrong with that. But the point that was made was that we don't think in the same manner when we look at our children. Besides this, there is also a problem when we talk about children to be city-centric. We always talk about children in urban cities, in urban areas. There is a lot of problem here. We've got drugs, we've got children on streets, and the same, as I said, often abandoned children. But there are a lot of children in the remote part of our villages who are children who are in conflict areas. The areas where there is a lot of this Maoist movement. Now, those are children, or in villages, are children who are generally below the radar. So when we talk about a juvenile justice committee or a juvenile justice system, it is those children as well who we need to bring within our sway. I'm sure high courts where these kind of problems arise, juvenile justice committee is looking into it. But at a national level, is there enough? I know of the National Commission for Protection of Child Rights, some couple of years ago, starting an initiative to deal with children in conflict areas, bring them back to school by having a program called the Bal Bandhu program, where but then somewhere that's sort of gone off the radar. The point that I wish to make is, firstly, juvenile justice committees have immensely helped the cause of the state, because they have started getting into administrative areas not in a confrontational way, but by aligning with them. A lot of work gets done when you align and push, cajole and nudge them. So it acts parallelly with what we do on the judicial side, because judicial side is like the last resort of someone who is harassed and comes up with against impediments. But if you can push them or nudge them, and some of the officers are very receptive, very passionate, as judges are, and they will do what is required. I'll give you one example that I recently encountered during this COVID time. We convened a meeting of the CWC's, JJB magistrates, in the beginning of April of 2020. And so it was brought to our notice that children who were incarcerated had to be released on bail. We passed certain directions. Children were released on bail, and a few days later, one child right activist, in fact, there were two of them. One was from our legal fraternity, the other one was purely a child right activist, brought to my notice the fact that, when you release children on bail from these homes, observation homes, in this COVID time, they have nothing. Their parents have nothing in terms of money. They don't have rations. And therefore, how are they going to take their child back and add another person to their already large family, and how are they going to feed them? So what was sought to be impressed upon me is that there are parents who are not willing to take custody of their children because at least if the child is in the home, he'll get to eat and stay alive. So we put this aspect before the concerned officers of the Delhi Women and Child Department, and when it was put to them, happily they agreed that they will pay every parent 1,500 rupees along with dry rations when the child is released on bail. And believe you me, this was done so quietly, in the sense that there was no hoo-ha about it. But this was an order which I was told later was replicated in various other states. So what the Juvenile Justice Committee can do on the administrative side is huge but understated. Mr. Ajay Verma, in the beginning of the introduction to this webinar, had said, we don't know enough. Now, there are two ways of looking at it. When you say we don't know enough, I would request some of you to go to the Delhi High Court website. We've tried to put up even the minutes of the Juvenile Justice Committee on the High Court link. There has been sometimes some lag, but if you go from 2017, 2018, even 2020, the decision that I'm talking to you about, which happened in April, those minutes are on the High Court link. And of course, the Right to Information Act is available. There is nothing that is not accessible today. And surely the Juvenile Justice Committee is not, let's say, wanting to hold back anything. So therefore, you have a system whereby you can know what is happening in JJCs. We have often, when approached, given access to academics, to activists, to go into homes and do their research and tell us what is it that is missing. So therefore, insofar as the Juvenile Justice Committee is concerned, it is my view that, and if you would talk to child right activists, they will also tell you that it has helped the cause of children. I can go on and on about what benefits have occurred, but I will reserve my comments for a later part because I know I am in the company of a very eminent academic, is Ved Kumari, who has helped the Delhi High Court in several ways and helped me as well, because I've called upon her whenever I have needed her help, and that you would like to hear her also. Interestingly, in your opening, you would say that Professor Ved Kumari was heading the Delhi Judicial Academy for a very long time, and lots and lots of JJB officers, which includes the principal magistrates, did receive training via the Delhi Judicial Academy. They continue to do so. Mr. Vishal Gogna, who I believe has also joined the webinar, has been imparting training to JJB officers, the CWC members, on the nuances of the JJ Act. So Ajay, I will leave it at this for the moment, because I know we don't have too much of bandwidth, as they say, in terms of time. So these are my opening remarks. If need be, I'll join you later.
Thank you, sir. Thanks a lot. May I request now Professor Ved Kumari ma'am, one of the inspiring personality and the subject on juvenile justice, many books, and I have also personally learned, and many of us who are here today are eager to hear her. Professor Ved Kumari ma'am.
Good afternoon, everyone. Justice Shagdar, very happy to hear you and see you. In this COVID time, it's such a pleasure to find real people, even if it's in the virtual world. I'm very happy to be here, and I'm very glad that Bar Council of Delhi has thought it appropriate to focus on children. Children have been a very, very major group of people who were forgotten in different scenarios during COVID, and certainly they have suffered a lot more than many other groups are. And I'm glad that you're talking about the evolution of Juvenile Justice Committee. But for me, evolution of Juvenile Justice Committee is only one of the events which have taken place for more than a century and a half then when we started talking about children. And I do want to very quickly mention that how we have moved, and I started working in the area in 1978 as my master's program. One of the papers was juvenile delinquency, and I've stayed with the subject ever since. And at this moment, I'm very disenchanted with the way things are going. Not that the efforts are lacking, but I think the approach is changed very, very negatively against children. When I look at the law from 1850 onwards till 2015, we were moving in one direction of extending our care to children. And when we use the word children, the mind talks about vulnerable children, the poor children, the trusting children, the lovable children. You know, we've got all these ideas about who the children are we're talking about. And we would think about the children who are exploited, who are abused. But when it comes to children who commit offenses, especially the heinous offenses, we forget that we were talking children. We immediately start talking about the children who have matured enough to take consequences of their actions. We do not think of children as mature persons in any other areas of laws, whether it's contract, whether it is traffic, what do you call that, licensing, driving license. We do not think of anything else that we keep on saying, no, they're not mature enough for any civil action responsibilities. But when it comes to the criminal law, immediately we have a discomfort because those children do not fit into a definition of children. And things haven't changed very much despite all our efforts in implementing the Juvenile Justice Act. My reading of the implementation of the Juvenile Justice Act right from 1960, we'll talk about Delhi. So 1960, we had the first model legislation applicable to Delhi, the Children Act 1960. And that was the first time when we actually said no child in any circumstance will go to jail. We've been saying it in exceptional categories in other legislations earlier than 1960. So from 1960 to 2015, we did a complete, we were going along on the same direction till 2000. And in 2000, the whole country said till the age of 18, no punishment, all children committing any offense has to be protected. But then Nirbhaya happened and we all went with a catapult to completely opposite positions, and law being an instrument of balancing the challenging ideas. The law was made, 2015 new law came in, and we created exceptions. And certainly I have been part of lots of training since 2015, and many of them were organized by the child welfare committees to train judges into the new law. And I was very glad very recently, even I went to Jammu and Kashmir when the whole amendments to place 370 got modified and the Juvenile Justice Act got extended there as well. And the Juvenile Justice Committee of the High Court immediately called for a training on the subject, and I was one of the resource persons there. So I do find that, yes, there has been focus on the legislation. And when I started working in the area, there have been any number of cases where right up to the Supreme Court, the lawyers did not know there was a law relating to children committing offences, a special law, Children Act. Any number of cases were there where the High Court judge did not know, the lawyer representing the children in the High Court did not know, the children, of course, did not know. And even in one of the cases when the lawyer filed the matter in the Supreme Court, in the initial petition, there was no mention of the Juvenile Justice Act at that time for the Children Act. But then they moved an amendment and said, oh, the Juvenile Justice Act applies to him and he should not have been punished at all. So there have been a number of cases where awareness was not there. And when I did my PhD work on this subject, only a few hundred cases were there in more than a century on the subject. And now recently I was trying to do another article and as to what's happening on the new legislation. And I find thousands of cases coming every month. Thousands of cases in the country and at the High Court level also. So for me, that's kind of, in a sense, a very good thing to say that, okay, now everybody has become aware of the law. And I'm quite sure everybody who's present today in this meeting knows that there is a Juvenile Justice Act. But for me, the problem is that knowledge has not resulted into accepting the policy and philosophy of the law, of the juvenile justice. When we said justice for children, we were talking about providing care and protection. We started it as a welfare measure, and then we moved on to saying, no, they have rights to the care. The UN Convention on the Rights of the Child has recognized that children have got rights, and we all know that children actually have got all the rights which adults have, but they have got some more rights, including the rights to development and education, and there's many rights which are specifically meant only for children. And when we say rights, certainly we have got an obligation. But the moment we have felt obligation and we are not able to discharge the obligation and the children falter, instead of saying we failed, we say the child failed, and child is old enough to know the consequences and therefore they should take the consequences. And I would refer to the juvenile accused in the Nirbhaya case. We put the whole blame on that child, and of course there was whole demand of hang the juvenile, not only the adults, but hang the juvenile, and we do know that the adults have been hanged, unfortunately, because of the law at that point of time. And the judiciary was very clear in its mind to say the law is supreme and that child was not hanged. But the demand was there, and I'm focusing on the demand. Why did the demand come? Who was that child who did such a heinous, barbaric offense? He was a child in need of care protection for 6 long years. Where were all those committees? Where were all those institutions? Where were the child welfare committees? Where were any state institution to look after the child so that he doesn't grow up in the company of people who would make him such a barbaric person? We did not ask that question because that's an uncomfortable question. We are only concerned with the emotional outburst at the offense. All of us were aghast at the offense. But does that mean that the children were responsible and all children who are committing offenses, they are responsible and therefore they should be punished? And for me, when I did the commentary on the new legislation, I was so pleasantly surprised because initially we were very much upset about the new legislation, asking for exclusion of 16 to 18 committing heinous offenses. We did a lot of campaign, but we failed and we got this law. But when I actually looked at the law individual provisions, I think God's grace has been with children in the manner in which provisions have been framed in the legislation. The provisions do not say that a child committing a heinous offense of murder or rape for that matter, even when tried as an adult, after transfer to the children's court, has to be sent to life imprisonment. There's nothing in the law there. The law very categorically say that even in such cases, the order has to be made in the best interest of child. But when I look at the High Court cases, lots of them coming from as appeals from the Children Court and from the proceedings in the Children Courts, and we are finding that JJBs are transferring the matters to the Children's Court of children committing heinous offences as a matter of routine. If it's a murder, transfer. Law doesn't say so. Because our mind has been so polluted by our approach or whatever happens post Nirbhaya that we believe that this is what the law says, but the law doesn't say so. Even though the law was enacted in view of the demand for punishment for children, law actually does not do so. But we do not want to believe it. We have seen, and today, of course, we do have a Supreme Court judgment where the Supreme Court has recognized that there is a fault in the classification of offences in the new law. As petty offences, serious offences, heinous offences. Heinous offences, as defined, refer to offences punishable with minimum 7 years of imprisonment or more. And serious offences are limited to offences punishable up to 7 years of imprisonment. So therefore, offences like culpable homicide not amounting to murder, 304, do not fall either in the definition of serious offences nor in the definition of heinous offences. And there have been any number of cases where the JJBs, instead of giving beneficial interpretation of this lacuna in the law, transfer children, including in Delhi. The Mercedes case is an example where the JJB did transfer the 304 charge case to the Children's Court, saying that it is a heinous offence. Fortunately, today we do have the Supreme Court interpretation saying that no, these offences have to be classified as serious offences. And till the time the law changes, and now there is a possibility of the law changing. And the grapevine is that is going to go against children. So for me, that's distressing. If you're talking about interest of the child, the legislation has nowhere, even the new legislation, you look at its preamble, you look at its general principles, fundamental directions, very categorically, it nowhere says child has to be punished. But our mind has got so polluted and we are forgetting. So we keep on thinking of children as vulnerable. As long as they're vulnerable, we are all there to look after them, to provide them care and protection, etc. But if the child has become abusive, and primarily because we did not take care when he or she required it, we do not want to take that responsibility. And I think that's where, for me, any institution which has been established, whether it is JJC, whether it is JJB, it is CWC, whether it is the Child Commission, we have to first understand who we are talking about. And certainly we all believe that my child would never commit a serious offense. It's only those other children. The moment we have this divide between my children and those other children and children of the other, I don't think law, even though on the face of it, it seems like certain negative steps have taken place, but possibility of protecting child is very much there. And I certainly believe that something which needs to be done is to question. And I certainly believe that the Juvenile Justice Committees in the High Court has a very good place in the system where they can promote discussions, clarification of ideas. And I think this is one of their jobs also, not only to oversee. I did hear Justice Shabda talk about wanting that, one of the target they put for themselves is that every district should have a JJB, and we already have 10 CWCs. It's a good step forward. That yes, certainly the legislations have to be implemented, but I think there needs to be a difference between technically fulfilling the requirements and getting people with right trainings and right attitudes, and then certainly having discussion. Because what happens in most of the training, and it was my experience at the Delhi Judicial Academy, we tried to change it quite a bit. I do not know how things are today, but when I joined the Delhi Judicial Academy, I did find that there was a lot of emphasis on information. on knowledge, on the law. Even though we do say judicial training should include 4 components: knowledge, attitude, skills, and ethics. There's very little focus on attitudes. And juvenile justice can never be fully implemented as it is meant to be without focus on attitude of people who are manning those institutions established under the law. So I think it's a starting point to establish institutions, but I think it's very important to ensure that the trainings conducted by the academies and by the registries themselves are also conducting training to ensure that there is a lot more focus on the attitude towards children, without understanding that even when the child commits a serious offense, he or she still is a child. In case of rape, for example, we do know 94% of rapes are committed by people known to us. They may be our family members, maybe relatives, friends, teachers, neighbors. These are people we trust, including children in that group. And in case of children, we have got this now POCSO, which has created really life hell for children. Because POCSO says any sexual activity between children is an offense one way or the other. Different categories of offenses under POCSO. And we also know that adolescence is an age of sexual explorations and sexual experiences, puberty onset. So at that age, and there are a lot of romance happens, there's a lot of running away happens, and judges are at a quandary as to what to do in love cases. So there are again, there's a whole range of children there, very young children involved in sexual activities, children on the borderline, 17 and a half involved in sexual activities. The law is not making the distinction anymore, and we are at a loss. And it's all this happening, all these laws are coming because we only think of children as vulnerable. We do not want to think of children as agents and still needing care. So we think that there is a contrast between a vulnerable person who requires all the help, but if that person has acquired agency, then they must take care, they must take the consequences of their act. Without realizing that children having the agency, certainly a 15-year-old knows what he or she is doing. There's no doubt about that. But is that enough? They know, and we do know, when we were campaigning, we learned a lot about child psychology and the manner in which the brain functions. And we do know that children at that age are the most vulnerable because of the manner in which the brain functions at that point of time. None of that gets reflected in the law. Most of that does not get talked about. Now, of course, we have got some judgments from the Supreme Court and High Court, which have recognized the brain development of children. But unless there is a wider awareness about how many of us in this book, for example, I would want to ask ourselves, I want all of us to ask ourselves that if my child had a girlfriend or a boyfriend and they indulge in sexual activity, what will we want? Do we want those children to be categorized as rapists? And the POCSO is actually a gender neutral law. So my daughter can be as much a rapist as my son can be. When it comes to my children, we say, no. This is all consensual, this is wrong and all that. But who gets into the net? Whose cases get reported? You and I can manage my children's future by having influences, by having contact, by lots of we have lots of means to ensure that law doesn't come into action. It's only when the parents do not want the relationship between my child, their own child and somebody else, that they will report the matter. So when there is a parent involved, not agreeable with the activity, then that gets involved, and any boy or a girl of 16, 18 can be held as an adult and tried as an adult for rape or consensual sex. But I think somewhere what I'm emphasizing on is that I think we need to have our minds to be cleared of this whole conception of children as only vulnerable, as exploited, as victims. I think we need to recognize that they are at this stage, and especially the adolescent children I'm talking about, because when it's the younger children, our heart cries and we're all there for them. But when it comes to the borderline cases, we get torn between the harm which has been caused by this child and whether this child can be still treated as a child. And I'm quite sure all of us would think that my 16 and 17-year-old son or daughter is a child. But when I sit in judgment, when I argue the matters for the state against children, I keep on saying, no, he has mental maturity. He is mature enough to know. And the only thing we need to do is to send him to prison. I think that's the mentality we need to challenge. And I'm quite sure that with the focus on juvenile justice through various mechanisms, including the JJCs, we have now created spaces where we can have these discussions. And if we can create those spaces, and I hope that some people in this group will raise questions about, should children committing serious offenses be punished? Should they be sent to jail? Will you want your child of 17 to be sent to jail because he or she committed rape? So I think I would stop at that. I'll hope that there are some questions and we can talk further.
Thank you so much, ma'am. Thanks a lot. I think we will invite the comments, but the only limitation what I would be requesting all the participants is that you may confuse, now after the session, you may not confuse the Juvenile Justice Board, CWC, with the JJC. So if you have queries and questions related to the JJC and this administrative powers and the focus on the rehabilitation and the implementation of the Act, please do ask the questions. I have one comment to request Justice Shagdar, is this, sir. How do you think, how do you visualize that the sponsorship system can be also an alternative options for the welfare of these children who to deinstitutionalize them to coming into the JJB system?
If you're asking me as to whether what is the best scenario for a child, whether he needs to be an institution or outside institution, and for that, if you have a sponsorship scheme, I think getting the children out of institutions is the best scenario. So you have, two roads that you take: either it's adoption or fostering. If you have, lots of states have foster schemes. Delhi also has, but unfortunately, they have not found enough people who want to act as foster parents for children. There are financial incentives given. See, at the end of the day, Ajay, I feel, and what Justice and what judges have been saying, and what just now Professor Ved Kumari says or said, it all boils down to only one thing: is JJ Act doesn't contain rocket science. You need to have compassion. You need to have people with compassion, and you need to have people, as I said in my opening remarks, who treat these children like they would treat their own children. If you keep that one, for want of a better expression, mantra in mind, lots of issues get solved. Cobwebs, both on the judicial and the administrative side, get solved. And since Professor Ved Kumari brought up the Nirbhaya incident, let me just tell you how JJC held, because we are on JJC. I was part of the JJC when the Nirbhaya case happened, and there was a lot of hue and cry. There was angst. People were angry. All of us were angry as to how the victim was treated by those criminals. And we know that there was one juvenile. But what happened in the process was, and this is something that the media has to take onus for, that they did not do enough groundwork to find out as to what was, if they were reporting that story, as to what was the involvement of the juvenile in that very grisly and gruesome act. Now, that child, because he was below the age of 18, and that was the law at that time, and we didn't have the 2015 Act in place, the child was, inquiry was made by a JJB magistrate, Judge Goel. And I can now share it with you, because these are committee reports. These are reports because in the interest of child, they don't come out. She actually found that the child had the least involvement, contrary to what the media story was, which drummed up angst against that child to the extent that some were demanding that he should be hanged as well. Now this, if this had happened, I think the society would have carried a very, very heavy burden. As Professor Vedkumari said, had it been a child of an upper middle class family or a rich family, would the media be doing the same thing? I don't know. They've done some wonderful job in this area. They've come out with some great stories, but I think here they missed something which was very nuanced and subtle. Now, how did the JJC help? I remember, and this is where I fault some of these persons who tried to report the story. We were pestered, our JJB members were pestered as to what was the date of release of that juvenile. The JJB member of that day came to the JJC committee and said, "Sir, I am in a fix. Everyone knows, because his period was coming to an end, everyone knows that he gets out on a particular day. What do we do?" And this is the first time I'm sharing this with you. We actually advanced the date of his release. We said, release him so that there is no hounding of the child. The child goes away, and wherever he is, even I don't know, because I said we don't want to know, lest, you know, this information, once it percolates to us, there is a possibility of a leak. We left it to him, but we gave him the mandate. So this is where JJCs step in, and as I said, in a very understated way. I mean, this is not something which is in public realm. And Justice Bhatt at that time was heading the committee. I was there. The two of us sat and we thought through as to how this has to be taken forward. I take Professor Vedkumari's point that a lot of people were unhappy with the change in legislation. What was happening with children till 2015, the philosophy and the policy of law was different. According to a lot of civil rights activists, as well as child activists, a lot changed when you segregated children into 16 and 18 with heinous crimes and the others. It's not easy to find out because their minds are not developed. But as judges, we work with what we are given as legislation. Then we interpret, then we, I mean, in the sense, as we all know, when eminent lawyers, passionate lawyers come before us, how the rigor of the law is chipped away. It sometimes happens slowly, so that it doesn't wear away too far from the core philosophy. As Professor Vedkumari has pointed out just now, and very rightly, that there are those, let's say, play in the joints in the present statute also, which judicial officers can work. She's right that you need to have a core philosophy, only then you can work those spaces. If you don't believe that children have to be given another chance, then of course you will come to a different conclusion. But if you believe children have to be given another chance, you may come to a different conclusion than the one who doesn't believe so. So what happens? What is the purpose of these trainings? The trainings are sort of arranged for judicial officers, for police officers, for other stakeholders to sensitize them about this core philosophy that children have to be given a chance. And you know, this malaise doesn't exist as since we are dealing with juvenile justice. Professor Vedkumari has said, you know, our judges are not sensitive enough. I can give her an instance of how academics act. I was faced with a case where one of the Delhi University colleges, there was an exchange program. There was this young lady who would come on an exchange program to Delhi. And there was this child, and it happens to children. She rightly said, you are a docent, you get attracted. And there is this perception when what you see in Hollywood movies, you think this is what happens actually in real life. And he did try to get intimate with her. The academics were very clear in their mind that the child has to be rusticated. I mean, there was no thought that if you rusticate him, he's in his final year, his entire career will get ruined. Can we come up with something which gives him a message that this was not on, that you cannot approach a lady without consent. You can't assume that she comes from a particular country. Therefore, this is the norm and the culture. But that's how I was presented with the case. Of course, thanks to my exposure to this area of the law, I came to a different conclusion. Fortunately, the appellate court upheld the judgment. It's a reported judgment. So the point that I'm trying to make is, it's our society as a whole, whether we are in the judicial system or outside the system, we have people who are not as sensitive to this core philosophy as some of us are, whether we are academics, we are professional lawyers. You'll find, you discuss it with your colleagues. On 2015 Act, you will get two diametrically opposite positions. There will be rarely a person who will be falling in the center. These are trained professionals. The reason for this, according to me, is also that there has not been enough done for the victim or victim's family. If the victim survives, you don't do enough. For the victim's family, because there is anger, there is hurt, you don't do enough. And the trouble is, sometimes our legislature looks to the West, which is America, and not to the Far East. In Japan, I did a little research around when Nirbhaya happened. In Japan, in fact, the age threshold was much higher, 1920. They were faced with something like a Nirbhaya moment, where one child had decapitated a police officer and put up a kind of a chit saying, "Catch me if you can." There was another child who had killed another person and wrapped him in a carpet. So the society was aghast, and they brought the age down. So this up and down is a reaction of the society, the larger society, to events which happen. Often you'll hear in discussions that these days unelected are telling us what to do. But the construct of the constitution is that unelected who are not, let's say, subordinate to public opinion can act as guide. It is the unelected, if they have this core philosophy in their mind, that they can do wonders, whatever the legislation is. So there is hope, and there is a lot of expectation from judicial officers. Whatever the legislation is, irrespective of whatever the grapevine is, I as judges, grapevines are something that we don't. But yes, as an academic, she is rightly concerned. And but I'm not one of those who would lose hope. I have a lot of trust in my judicial officers. Yes, they falter, they learn. It's a learning process. We mature as judges. I was a judge appointed in 2008. What I was in 2008, I'm not the same in 2020. You are a lawyer in X year, you are not the same. You mature over a period of time. So that's my thought. Sorry, Ajay, I took longer than...
Thank you so much, sir.
To say a couple of things to the question you raised earlier to Justice Akhtar, when you talked about institutionalization of children and when should they be released. I think it's an important point that you raised, and I would want to refer to 1985. We had the Beijing rules, which said institutions should be used as a measure of last resort and only for the period necessary for which they should be in the institution. We said the same thing in the convention, the UN Convention on the Rights of the Child, that institutionalization is the measure of last resort. We have the same, we are party to both the documents, and therefore certainly for me the question when all this bail was granted to children during COVID time was that if they could be released during COVID, why were they needed to be in the institution in the first place itself? If they were safe to be released in society, and there were institutions or families or places where they could go without, during COVID, they could have been at the same places even without COVID. But our whole philosophy, Motiram said long ago, bail, not jail, and Juvenile Justice Act specifically says only 3 reasons to deny bail, but we still keep on getting cases where children could have been sent home but are not sent home because we have not got out of our penal approach to offences. That was one point I wanted to make. The second one was, which I think Justice Akhtar very beautifully also said, 2 things he said. One, he said that we work with what is given to us. Surely. But then he also said that how we work with that, with what is given to us, is also dependent on who we are. And I think that's where I come from. That I certainly believe that no law has any absolute meaning. Interpretation given to the law as given is dependent on what is the approach of the judge. And I, Justice Shakda, certainly believe that we've got lots of judges which are really good. We had 5 High Court judgments before the Supreme Court judgment came on heinous offense, including Delhi High Court. Each one of them said offenses which are not falling, which are not punishable with less than 7 years of imprisonment are not heinous offenses. The Supreme Court only finally said so, but 5 High Courts, Bombay, Delhi, Punjab, Patna, and I think there's one more. All of them said, no, this is not heinous offenses. So this is all High Courts. And I certainly know that lots of High Court judgments have said JJBs have to apply their mind. They cannot routinely transfer the matters. They have to do the assessment. All the things are there in the law. So our hope is, and there has been, if there has been bad judgments or ignorant judgments coming from ignorance or prejudices, there have been equally or even maybe more cases which have come from the right philosophy. But for me, one child lost is also a loss, and therefore we have to work on that. And then the third point which Justice Shakdar raised, and I do want to emphasize on that we do not do enough for the victim and the family. And I think that's a very important point for us to think about, because today, and when Nirbhaya thing also happened, and the convictions happen and the executions happen, justice has been done. When a man or a woman or an offender is sent to prison, justice has been done. But has really justice been done? What is the concept of justice? And I'm trying to raise the issue of restorative justice, where we do say that we need to work with the victim's family, with the victim, with the accused and accused family. I've seen in my training programs number of times the JJP and CWC members are saying, ma'am, the family of the accused child is, or the child who's found to have committed offense is not ready to take him back. So it is not only that the victim, and when we talk about rape victims, for example, the only 2 victims are not there who are affected by the offense. She is not anymore welcome in this school. She doesn't feel comfortable in this school. I will not allow my daughter to now play with her. All these are the consequences because we have not worked effectively with the persons who are affected by the offense. The only manner in which criminal justice responds is send the persons to the prison, send him to punishment, either hang him or imprison him for a long time, and justice is done. But I think Justice Shakda's point is to be really taken note of and find ways and means that juvenile justice does provide for that occasion for us in the form. It doesn't use the word restorative justice, but I've been saying in my training program that the 2 provisions of community work and group counseling does provide us spaces where concept of restorative justice, where we want to bring up the original state of mind and relationship between parties. These parties may be victim and the family. It may be because we do know rape victims are not very welcome in their own homes. Forget about everybody else. So certainly there is need to focus on that, and I didn't want this point to be not emphasized. This can never be overemphasized, and I wanted to reinforce the point Justice Shakdar raised, that we need to think in terms of justice by talking about working with the families of both sides, I would say. Thank you.
Thank you. May I request Mr. Vishal Gogne, Deputy Director, Delhi Judicial Academy, and to share his comment.
The comment is in the context of training, of all the stakeholders, and I would want to contextualize in the context of the JJC, especially because the former chairperson of our academy, Professor Ved Kumari, is here. Now, it's correct that initially, as we started trainings about a decade back, we were very heavy on information. But as time went on, we've started doing multi-stakeholder trainings where we call the JJBs, the CWCs, the SJPUs, the DCPUs, even the superintendents of the observation homes to our programs. And how we take the guidance of the JJC is that before each such training, because we're mindful that the JJC is essentially also on the administrative side. So it has a tremendous, say in the whole ecosystem. So we take the guidance of the JJC in developing our agendas. And over time, we have moved away purely from questions purely of, let's say, information sharing to concepts like child psychology. Because I feel the purpose of these meetings and training is to develop an ecosystem which which aims for an understanding of childhood and not as children just in as incident of the JJ Act. So we talk about peer influences, we talk about social media, we talk of age of criminality in terms of neurological development, developmental psychology. And the second key area on which we seem to get a lot of mandate and directions from the JJC is that we must look at non-institutional care. Just the last training we had a month back, we had a full day of training on developing non-institutional care within Delhi. We realized the limitations in terms of governmental support at this stage, but we were able to secure experts from states which have as many as, let's say, 20,000 foster care families. So I think judicial training has come a long way, and primarily under the guidance of the JJC in developing a better understanding of child rights per se. So that's my comment. Thank you.
Thank you, Mr. Gokhale.
Vishal, if I may say one thing, that even when you talk about psychological, it's good that we have to have this multidisciplinary training in the academies. My concern is that whether we are using participatory methods, because for me also the teacher I've evolved over the years. Previously, I will bring lots of information, but it's all information I'm giving, even for the psychology. But do I incorporate teaching methods where I can find out what do my participants think, has anything changed in their mind, in their attitude? And I think I'm quite sure that you are aware of that, and some of the resource person must be focusing on it. But that's a very important thing which I have learned as a teacher, that unless we find out what our trainees are taking from it, whether they're taking even about child psychology knowledge about it, or whether their attitude has changed on that front.
We have one of the judicial member here from Delhi, Madam Anu Grover Baliga, and she would like to give some comment. I request Madam.
Good afternoon, everybody. I just wanted to also know if the Juvenile Justice Committee could also look into the children of the accused persons. I had dealt 2 years back with a murder convict. He was convicted by me of rape and murder, and his wife was deaf and mute, and he had 2 children aged 5 and 7. So while convicting him, I did pass directions to the state legal authority that, if we don't take care of these children, they might ultimately fall onto the wrong path. There is no legislative provision for a judge while passing these directions, to ensure that they are complied with. So would the Juvenile Justice Committee on the administrative side think of the children of the accused who are really left with nobody to look after them? Apart from CWC, because here the question would be that the mother is there. You see, all children are not necessarily brought into the ambit of CWC if you really think about it that way.
Ajay, can I answer? You want me to answer this, or
Yes,
I don't know?
yes, please go ahead, sir.
Yeah, Ms. Baliga, this is an important point, and this point takes me to what I was saying a little while back. It is evident that your philosophy is to help children, and the philosophy of the Act, I believe, is agnostic to the child's parentage. Now, whether it is the child of the accused or the victim, both at times are in need of care and protection. So therefore, what you did is commendable. You don't need, as I said, there are some unspoken areas in the Act, and as long as you are near the core philosophy, I don't think any superior court or the appellate court could have found fault with what you did. As JJC, I can only tell you what is happening in Delhi is, we are not only looking at children. If a specific instance is brought, I have no doubt that some directions have to be passed, we will pass. I'm sure on the judicial side, the High Court will do the same. But insofar as JGC is concerned, we are not only dealing with children who are in homes, we are dealing with street children, we are dealing with children who drop out, we are getting the corporations and the Delhi Education Directorate to map as to how many children have dropped out, because one of the reasons for dropping out is, say for example, drug addiction. And we are trying to bring them back. Now, strictly speaking, they are to be looked at by corporations or the Directorate of Education. But the JJC on its own has expanded its ambit and scope. And as I said, on the administrative side, it's easier to push the government, because then they don't get into these areas. No, this is not your jurisdiction, etc. They're happy to help. Yeah, there are flaws. It takes time. But so what you did was great. Now I can give you another instance. Recently, the JJC actually went to an area in Delhi where there is a lot of drug abuse and substance abuse. We interacted, so we actually went onto the ground, as I say, ground zero. We interacted with the mothers there. And when we interacted with them, all of them pleaded that, children in this area are being supplied drugs and you people need to do something. Here again, we got the DWCB's officers there, we got the police officers there, they heard the mothers and they realized that something is going wrong, terribly wrong. So we set up clinics there. It is a pilot project. If this succeeds, we can then replicate it in other areas, because there are a lot of areas in Delhi which are drug infested, and I'm sure this is the same problem. So the Act doesn't tell you to do or not to do anything. I am very clear in my mind. As long as you do the right thing, courts above find a way of sustaining that order. So I would go with what you did. If I had something on my plate, I would do the same.
Thank you, sir.
I know. Would you
Yes,
not
ma'am.
think that this provision in the definition of the CNCP, clause 5, who has a parent or guardian, and such person or guardian is found to be unfit, certainly should not unfit, but incapacitated by the committee or the board to care for and protect the safety and well-being of the child? Why would this child not fall in this category of CNCP? And therefore, if he falls in the children fall in CNCP, certainly CWC can do. This whole process of sponsorship and finding support for the children is very much within the law. So I
True,
don't
ma'am.
think this was done without the provision of the law. You are very much you've done the right thing and also within the provisions of the law. You just didn't mention it but I didn't mention it. But I think it is very much possible within this language.
Yeah, there is a precedent long ago. I remember Justice Mudgal's judgment, where someone had been convicted of murder. The children and the mother was not there or something, and the children were abandoned, and the High Court passed directions for they being looked after. So Professor Vidya Kumari is right. If those provisions can be worked, nothing like it. But as I say, if something doesn't, this is one instance, but something doesn't prohibit in the Act, that's the first principle you follow. You can do it.
True.
Unless there's an express prohibition.
Ma'am, Ved, sometimes what happens is the CWC's action somehow doesn't give you the desired result. Now, in the same case, the victim was a woman who had 3 daughters. Now, because CWC had stepped in to make sure that the daughters are looked after, the 3 of the daughters were sent to different homes. One was in UP, one was in Delhi, because they were of different ages. So I just couldn't digest the fact that, the 3 sisters who would have been so happy to be there for each other when they've lost their mother are now put in 3 different homes. So you see, somewhere sometimes you don't want to kind of go to CWCs, thinking that, you may end up.
Whenever the academy, we had this distrust of each other, and
True.
organized because there were the CWC members who said, the ACMMs do not know. They just released children, but when we asked them to work in groups, we made groups of one CWC member and one ACMM, and they found that both of them were coming to the same conclusion. So I think there might be individual cases where you are not satisfied with what the other did, and that can happen at any stage. But I don't think as an institution, when we're talking about, we can bypass.
True,
Thank-
ma'am. True. That's
Thank
it.
you, ma'am.
Any
We
individual case.
I'm sorry. To keep the time track, we have Honorable Justice Mehta from Rajasthan High Court. He's also chairman of the JJC of Rajasthan. I would request if my lord have some comments to make in this during the session. I heartily welcome him.
Good
For this.
afternoon, Mr. Verma. Good afternoon, the Honorable Justice Shakdar. Good afternoon.
Hi, Sandeep. Hi, Sandeep, to see you here. Good.
I got the link from the judicial officer, and since Justice Shakdar and Madam Vedkumari were to address, I couldn't resist the temptation of barging in. I could join only midway because I was having a webinar of the academy, and I was participating in that also. So in any event, as usual, once we have Professor Vedkumari and Honorable Justice Shakdar on board, the discussion is bound to be vibrant, and it was undoubtedly.
So, Sandeep, you tell us about your experiences.
So I am telling you,
Since you've done a lot of work, I know,
yeah, of course,
in this area.
being involved in the JJC for the last about 7 years, it has been an enriching experience. And the one thing which really I could do in Rajasthan is by way of that continuing PIL, we have managed to get the funds of the ICPS reappropriated for the purposes of establishing training centers for the juveniles. This is one innovative approach which we have applied. The important issue which Professor Vedkumari brought up regarding that referring the child to the children court under section 15 for the heinous offences. If Professor Vedkumari must have come across, there was one matter before us in the division bench, a most unfortunate turn of events wherein a child, a girl of 14 years, was of course a Adivasi background. She was married off to a boy. It was a love marriage. The boy started suspecting her of infidelity and having an illicit affair with his own father. So there was some tussle between the husband and wife, and the girl, she one particular night, she picked up an axe and hit the boy. The boy was, of course, a major, had become major by that time. It was a case of a murder was registered. Unfortunately, the girl, soon after completing 18 years, was sent to the prison rather than the continuing her in the facility. So she was convicted, sentenced to life. It was probably one of the most shocking cases which came up before me. And that is a judgment by the name of Durga, wherein the Rajasthan High Court Division Bench has given extensive directions on how the process of evaluation is to be undertaken. Of course, improvements are required, even with better thinking and better discussion. More discussion will take place, and better conclusions will be drawn. But broadly, we have said that while dealing with this aspect, you have to keep in mind that is a paramount consideration that the person you are dealing with is a child. You don't proceed with the presumption that he or she has committed the heinous offense, and so we have to send the child for a trial as an adult. So that judgment probably has been circulated everywhere, and people have I've received feedback that thereafter the rate of references has come down, as it should. So broadly, these are things, of course, with the COVID, we have stopped having those meetings wherein important discussions on taking this JJC and the issues of children forward, they have now met a roadblock. But with Honorable Justice SR, but now heading the committee, I suppose that we'll take a zoom in that direction. Thank you, Mr. Verma, for giving me this opportunity. And it was a fantastic opportunity to be back on board with Justice Shakdar and Madam Vedkumari. Thanks a lot.
Thank you, Sandeep.
We have a last question, and Ms. Bharti Ali.
So much, Ajay, and thank you for organizing such a useful webinar. I think there are some very, very important questions that are coming up on the chat box. And I just hope the speakers will also read the chat box and read those questions. But just to reiterate, there is immense practice even in the group that you have today. So you can imagine, we have so many examples that we actually need to start documenting those. So one of my requests to Justice Shakdar as the head of the Juvenile Justice Committee here would be to invest in documenting these good practices, which will really go a long way in strengthening the training curriculum as well as imparting, and sharing of information. And my second request to Justice Shakdar, I'm so grateful to him always. He's so receptive towards, suggestions and recommendations. I can't thank him. I have no words really to thank him enough. I would request him to actually help us see the sponsorship scheme in Delhi come to reality. A lot of discussion that has happened as to why do CWCs don't do certain things. Actually, my conversations with CWCs have told me that the absence of a sponsorship scheme and guidelines hinders them from actually finding sponsorship for any child. And the situation of all kinds of children in difficult circumstances can be taken off through a good sponsorship program with good follow-up. We'll be very, very happy to assist the JJC in Delhi in evolving such a scheme. There is process underway in Maharashtra. Maharashtra already has a scheme, in fact, so we can draw from other states as well. And the scheme about children of incarcerated parents definitely needs a revision, because at the moment, the way it was conceived initially, it talked about any one of the parents, if they were in prison, then their children and the rest of the family could be supported. But finally, the shape that it took was that it said if both the parents are incarcerated, only then the children can be supported. Now, this scheme also needs to be taken to scale and at a national level, but with ensuring that even if a single parent is incarcerated in jail or any other place, then the children are taken care of. Thank you so much for this wonderful, wonderful webinar.
Thank you, Bharti.
I know we're running out of time, I think, but Bharti was humble enough not to tell you people that she was instrumental in one of the initiatives that I just mentioned. I didn't mention her name because I wasn't too sure she wanted to, but now that she's on the webinar, this direction of 1500 and ration, she brought it to our notice, and we immediately convened a webinar, a VC meeting, and the state helped us. So we were able to help the children without getting into a confrontation zone. As far as Bharti Ali and people who are working in the area are concerned, they have often come up with very, very constructive suggestions. So therefore, I can assure her that the JJC in Delhi, and I'm sure I know Sandeep is of the same view and of the same philosophy, that we will push this as well. Both points about the sponsorship schemes and this problem that we have when parents are incarcerated, and even if it is one parent, why shouldn't the child be supported? Is something that requires looking into. Suggestions are welcome. We are available, and I think Sandeep wants to say something on this. Sandeep, please go ahead.
Yeah, regarding this aid to children whose parents are incarcerated, there was another very gruesome incident before us. The father had assaulted the children, and there were 3 small girls. One died, and the other 2, they were in a bad shape. Now that, unfortunately or fortunately, whatever you call it, the appeal of the accused, that is the father, came up before us, and we were presented an application that the mother and the 2 girls, the survivors, they wanted to compromise the matter with him, so that the court may take a lenient aspect on the sentence. Now I called the girls in the court and I was shocked to find they were decapitated because of the injuries. And mind you, they were injuries by sharp weapons. And it was years down the line. The case was somewhere around 2008. So what we did was that, affirming the conviction of the father, Rajasthan fortunately has a wonderful victim compensation scheme. So we directed maximum compensation to the girls, holding that the compensation scheme is retrospective in nature, because the scheme was introduced in 2011, whereas the incident was of the year 2008. So we directed that the victims will be compensated, and all facility of education, etc., under the RTE Act will be provided to them. With the Rajasthan State Legal Service Authorities was also involved. And in this manner, these are small things which can be done whenever, of course, they come before you. If not, Professor Ved Kumari and Bharti Ali are here.
But you know, Sandeep, I want to say something. I want to comment on this victim compensation scheme, and I'm sure Bharti, Ali, and Mr. Professor Ved Kumari also have their views. You know, sometimes we leave it just to compensation. As a judge, I realize that compensation is not the only thing that the victim requires. He or she requires psychiatric, help. They require help from psychologists. They sometimes require rehabilitation. You know, suppose that child, sometimes children are also the source of income, etc. I don't know. So those are, there are several areas that we as judges sometimes need to look at. And so I'm quite conscious of that, but you need to get an opportunity to do all that. See, as judges, we wait for that opportune moment to work this forward. But yeah, with the state, we can on the administrative side do more, perhaps. I take that point. Professor Ved Kumari, you want to say something on this?
Thank you. May I now request, I think we are running over time, and I think we need to conclude. And I request Mr. Jatan Singh, Vice President of Delhi High Court Bar Association, to give the ending comments and vote of thanks in this.
Honorable Justice Rajiv Shagdar, Judge of our Delhi High Court. Honorable Justice Sandeep Mehta, Judge Rajasthan High Court, who joined us as an interjector, but he has given his beautiful comments and judgment of Durga. Honorable Professor Ved Kumari ji, my own faculty of law, judicial officers of the Juvenile Justice Board of Rajasthan, Mr. Vishal Gogne, Additional Director, Judicial Academy, and his officers who are taking training in the Judicial Office, Judicial Academy. Ms. Anu Grover Baliga, the Secretary of Delhi High Court Legal Services Committee. Ladies and gentlemen, मैं तो सिर्फ अभी इतना ही कहूंगा कि आज जो वेबिनार हुआ है दिल मांगे मोर, तो definitely we are going to have a longer session later on. But on behalf of the International Bridges Justice to India and on my personal behalf, it takes me immense pleasure and privilege to thank Honorable Mr. Justice Rajiv Shagdar for his electrifying speech about the evolution of Juvenile Justice Committee in India and making us aware about the history of JJC in India, and also telling us, all the participants, that what is a JJB, Child Welfare Committee, and related aspects of JJC in India. We could not, that's what I said in Hindi, we could not have asked more or for a better speaker to deliver the talk on this subject. I also would like to thank Professor Ved Kumari from Faculty of Law, always teaching us new things, and this was a very good subject, for joining us today and giving her perspective on the topic. I shall be failing in my duty if I do not thank the judicial officers and members of the Juvenile Justice Boards of Rajasthan who have taken special permission to join this webinar from the Rajasthan High Court, and probably Justice Sandeep Mehta is one example who is sitting with us and joined us and gave his perspective. I also would like to thank Mr. Vishal Gogne, the ADJ and Additional Director of the Judicial Academy, Delhi, who joined us and also spoke to us on this webinar. I would like to thank Delhi Bar Council and Mr. Ajendra Sangwan for associating with us in this program. Big Bar Council of Delhi is a statutory body. I also would like to thank the participants. There are many judicial officers, and this webinar, I will congratulate Ajay. It is a hit. It took more than 600 participants who have joined the link, and there are others also. My special thanks to all the participants who have joined us, and the most important thing is that I must admire their patience and sincerity by which they are sticking to the program. We have stretched the program from 1 hour to almost more than 1 hour 45 minutes. I also would like to thank that Ajay. Without Ajay, because I saw that this is by far the best webinar we have with Ajay we have organized. In the last program of last webinar, where Justice Seema Kohli spoke on the subject of sexual harassment at workplace. So this is by far the best. I thank everyone for participating, and thank you all. Take care of yourself in this COVID. Be safe. Thank you so much.
Thank you.
Thank you.
Sir.
Thank you.
Everyone.
Thank you.
And with this, we will end. And I wanted to assure the participant from Rajasthan that soon we will be definitely organizing session in Hindi. I understand there were comments that many of you wanted to have sessions in Hindi, and we have many good resource person. I will request them again to come and enlighten you on this subject. Thank you, everyone. Stay safe. Take care. Thank you.
Thank you.
Thank you.